Welcome back. I am the loud little ducky. Today in the Owens v. Echard case, we are going over Echard's attorney who has responded to the dismissal and judgment motion. And then we also have a minute entry from the judge that was put in on the motion to withdraw Rule 26 sanctions, which is basically what this dismissal and judgment motion is fully focused on. So let's jump in to what Greg Woodnick has to say to Gingriss's motion. So we have May 15th, 2024 in the matter of Owens v. Echard, response/objection to petitioner's motion for judgment on the pleadings and renewed motion to dismiss assigned to the Honorable Judge Matta. So if you remember when we went over a few days ago this motion from Gingriss, I said that really this motion should have never been drafted. It shouldn't have mattered because the Woodnick and Clayton had already put in a withdrawal of that motion for Rule 26 sanctions. So this should be null and void. I get why they didn't, because a ruling hadn't been put out and filed into the docket and stuff. So I can see maybe Gingriss putting this motion out because they hadn't heard about whether the Rule 26 sanctions withdrawal and stuff being taken off the table yet. But I think Woodnick has a lot of similar things to say that I did, kind of, about the fact that, okay, even if we take the Rule 26 sanctions off, it still doesn't mean that she is not going to have to pay sanctions of other sorts, or she's not going to have to pay attorney's fees for these pleadings. Like, she can still have to pay sanctions. So this little win for this sanctions Rule 26 thing, if it gets taken off the table, is not that big of a deal. Whoop-de-doo. And it doesn't dismiss everything else. So, okay, you can have this little bitty win, but that is not going to take away the rest of the case. It just takes away this particular matter, which Clayton and Woodnick withdrew and decided, okay, we're not going to even deal with this matter. Let's just deal with the main things in this lawsuit. So let's go on to see what he actually says. So Woodnick starts off by defendant/respondent Clayton Echard by through counsel undersigned hereby files his response and objects to the plaintiff/petitioner Laura Owens' motion for judgment on pleadings and renewed motion to dismiss filed on May 10th, 2024. General availability of attorney fees and sanctions. Before addressing the balance of the motion on its face, the court must be aware that Laura's entire argument presents a false choice fallacy, an attempt to limit both the scope of the pleadings and the court's authority. Rule 26 is not and has never been the exclusive source of the court's authority to award attorney's fees, and it does not govern Clayton's substantive claims for relief raised in the pleadings. Therefore, the question before the court is not whether it can award sanctions under Rule 26 or no sanctions at all, as Laura falsely frames in her argument. Right. Owens thinks if she gets Rule 26 sanctions taken off the table, that she can't ever be sanctioned in relationship to this case, and that is just not true. And if Gingriss hasn't explained to her this, or she hasn't gotten it through her head, then that's a them problem. That's not a Clayton and Woodnick problem. Rather, the question is whether Clayton is entitled to adjudication on his claims for fees and sanctions under any authority invoked in the pleadings or inherent to the court by virtue of statutorily mandated duties. The answer to the question is clearly yes. Laura knows, or at least should know, based on the plethora, my favorite word. Like, plethora is probably my favorite word in the whole entire world. If you have not watched The Three Amigos, you need to. Of written communication and filings about this issue, that her proffered Rule 26 or dismiss the action dichotomy is both frivolous and misleading. Title 25 contains at least 3 statutes that expressly instruct the court to award attorney's fees and sanctions a party in response to unreasonable conduct in litigation. ARS 25-324, attorney's fees and actions under 25-401 through 25-417 for unreasonable conduct. ARS 25-415, sanctions for presenting false claims or violating orders compelling discovery in family law actions. Notice Woodnick's citings are for family court, not criminal court, because there is a distinction. And ARS 25809G, attorney's fees for unreasonable positions in paternity proceedings. Clayton has already articulated in several filings, including in his motion for leave to amend, amended response, response to objection, to petitioner's motion to dismiss, and motion to withdraw the motions for sanctions pursuant to Rule 26, the statutory basis for his claims for relief. Moreover, those provisions apply to all proceedings brought under the relevant chapters of Title 25, of which this paternity action is one example. Every litigant has a notice of the court's duty and authority to sanction unreasonable conduct in family court actions. Rule 26 is a procedural mechanism for sanctioning a party for the contents of their filings at any time, even before final resolution and notwithstanding the prevailing party in the action, and does not replace, supersede, or otherwise affect the statutory claims for relief whatsoever. See footnote 1. To crystallize this point even further, Rule 26 is not even the exclusive source of sanctions in the procedural rules themselves. The court can sanction a party for service violations, Rule 43.1, discovery violations, Rule 51 and 65, and failure to participate in various aspects of the proceeding, Rules 66, 67, 71, and 76.2, to name a few. Arizona courts have repeatedly recognized that when a substantive statute conflicts with a procedural rule, the statute prevails. Albano versus Shea Hose Limited Partnership and Marriage of Waldron. Court rules may not abridge, enlarge, or modify substantive rights of litigants. Rule 26 governs relief pursuant to Rule 26 and nothing more. Even if Laura's arguments interpreting Rule 26 were correct, a conclusion Clayton certainly opposes, the net result on the posture of the case would be absolutely no change at all from the existing trial scheduled on the merits of the pleadings. Accordingly, her prayer for relief, improperly styled as a motion for judgment on pleadings and renewed motion to dismiss, was already moot before it was even filed, because Rule 26 is not at issue. Right. The motion was withdrawn. So why are you still yapping about it? Stop it. The motion has no bearing on the resolution of this case, as detailed in prior filings. By withdrawing his Rule 26 motion, Clayton hoped to avoid noxious agenda of papering the court with dozens of pages of meaningless debate on this topic, but Laura appears determined to have this purely theoretical argument regardless. Is it Owens that wants to have this argument, or is it Gingras that wants to have this argument? Response to motion for judgment on the pleadings. As for his response/objection, Clayton states as follows. Number 1, Clayton provided written notice as required by Rule 26, Arizona Rules of Family Law Procedure, through emails and filings. See footnote 2. This is all addressed ad nauseum in Clayton's motion to withdraw, which was provided as an exhibit for the court's convenience as a litany of unnecessary filings designed with the covert goal of delaying or otherwise avoiding trial, as here with the motion for judgment on the pleadings have followed. Goes on to say, as addressed in depth in his motion to withdraw, Clayton's motion for leave to amend, filed December 12, 2023, Exhibit 1, provided notice of his intent to seek sanctions against Laura and cited Rule 26. The court granted leave to amend and accepted the amended response, also citing Rule 26 and indicating an intent to seek sanctions against Laura. On January 25th, 2024, so she was notified in December, and then December 12th, yeah. So December 22nd would have been her 10 days if it goes by just plain 10 days, or if it goes by business days, but I think it just goes by straight 10 days. On January 25th, 2024. So that was an amended response. On December 28th, 2023, more than 10 days after being notified of Clayton's intent to seek Rule 26 sanctions via motion for leave to amend, Laura moved to dismiss her petition because she was cryptically no longer pregnant. Imagine that. I don't know where they could have gone. Clayton timely objected. On December 25th, 2024, the court deliberately indicated it was not dismissing the action because Clayton is entitled to resolution of his claims for a finding of non-paternity, attorney fees, and sanctions. See minute entry dated 1/25/2024. See minute entry dated February 14th, 2024. It is ordered denying petitioner's motion to dismiss. See also Rule 46A(1)(b), prohibiting voluntary dismissal without court approval after an answer is filed, and permitting the court to dismiss a petition on such terms and conditions the court deems proper, including the resolution of any claims by the responding party. Holgate v. Baldwin. The court upheld an award of sanctions despite the parties not sending separate notice of their intent to seek Rule 11 sanctions, finding that the safe harbor period commenced when the parties filed their initial joinder motion evidencing an intent to seek sanctions. Emphasis added. Yeah, she had responded. And so she wants to go through with this. And you don't have to give them a separate thing. You just have to tell them. And it probably saves time and money and paper to just put it in a filing that you're already filing. Put it in one of your motions instead of having to file another motion which costs more money. Here is an email from Gingras to Woodnick on May 9th, 2024. It says, Craig, see the email below from Maraschini? I haven't responded to him. Since I still don't know if he's represented by counsel, I don't really consider Randy Pollock to be representing him with respect to the Arizona case, since she's not licensed in Arizona and hasn't done anything to appear in the case on his behalf. Still, don't want to communicate directly with Mike unless or until someone confirms he is not represented, or if he is, that I have consent from counsel to talk to him. I realize Mike isn't actually your client, to my knowledge, so I don't know how much control you have with him, but I'm hopeful maybe you can get Mike to change his mind. Didn't Maraschini message you on the 8th? I'm pretty sure he did. The 6th or the 8th. But okay. And you did tell him you didn't want to talk to him for that. He apparently unhappy about something I tweeted yesterday, which is why I removed after seeing his email. This doesn't seem fair. Life is not fair. And you know what else is not fair? The fact that she has done this bullshit to multiple people, a plethora of people, if you would. Laura is being attacked relentlessly on a daily, virtually constant basis by people on Clayton's side. But somehow, if I say or do anything to respond, this is somehow deemed outrageous. It's really frustrating. There are two sides to the story here, and one side seems to be monopolizing the narrative, often with less than total candor. I try to have total candor. I have wanted to see Owens' side. Many of us have wanted to see it. But everything that comes out is a lie. And she's in the midst of a public litigation right now. You are putting out stuff just to be spiteful. You're not doing it to do anything except for be vicious. You want to put out some evidence that helps your client? Then do so. People have invited her on to talk. People have invited you on to talk if you want to. Come on here. We'll have a conversation. I can be respectful. I will talk to you because I can see zealous advocacy, but I can also see that you're being a huge pile of shit when doing things that you're doing because you impulsively act instead of thinking before. Ask for forgiveness later is what you do. And it's just not how you need to be portraying yourself. Anyway, I want to keep the lines of communication open with you, and I promise to keep things on the same professional level as the conversation yesterday, but I just need to let you know that if Mike won't speak to me, then I have to go back to my previous position that I am going to ask the court to exclude him from the trial. That's just what the rules require here, so if Mike is willing to be flexible, then I can. You're not willing to be flexible. He has said he will talk to you through email. You won't message him back in email. You want a phone call. He doesn't want to do that off the record. And if you want to try to exclude him from the trial, then try to exclude him from the trial. Just do what you're supposed to do as a lawyer. Sometimes what lawyers do, we don't like. But we can understand if it's on behalf of their client and it falls within the lines of legality. But when you're not doing that stuff and you're doing extra stuff that is not necessary, it's hard to look at you without having a horrible judgment of you. Again, this is not any sort of criticism directed at you. It's just hard when I'm dealing with people who demand that only their side of the story can be told. That is not true. We have given plenty of chances, and we will still give plenty of chances. If something comes out in June that none of us knew that can shut us all up, then we will apologize and say, you know what? They had this. They didn't put it out to the public, but they had this, and now we can see why she thought this and all of that. But because there's been so many lies and manipulations, we can't believe anything that comes out of her mouth or out of her phone and computer. Because time is so short, I need to know ASAP if Mike is standing on this position. If he is, I will need to file another short motion in limine seeking to exclude him for non-disclosure. P.S. I sincerely do appreciate you taking the time to talk yesterday, and I am hopeful that if you need anything or want to talk further, you can just pick up the phone and give me a call. Those direct conversations are so helpful. Emails just don't have the same benefits. I don't see why they can't, but okay. Then on Monday, no, before he sent this, there was an email from Gingras to Woodnick on April 22nd, 2024. It says, David, video testimony. I agreed that all witnesses, not parties, can appear virtually if they are not local. That seems to work well with bench trials. To be clear, we are not stipulating to the admission of your expert's report, but his testimony can certainly be done via video. So he does know this is a bench trial. I'm glad he knows, because I was starting to doubt if he knew, because he keeps citing things for jury trials. But it's good to know he actually knows that it's going to be a bench trial. My preference is to have everyone testify in person, if possible, but I am just not 100% sure about Dr. Mudchill's travel plans. He lived in Phoenix for the last 30-plus years and just recently retired and moved to Florida. But he has family here in Arizona, and he comes here regularly. Given a choice, I'd like him to appear personally at trial, but if he can't make it, I guess we'll be fine, assuming the court allows it. I don't object to you calling anyone by video, but again, I don't know Judge Matta's policy on this stuff, which is why I asked. To the extent it matters, I'll stipulate to video if you want it. Okay. So they're talking about video testimony that some maybe will be appearing over like Zoom or something. The second thing is trial time. I will streamline my presentation to fit into our allotted hour. Laura invoked Rule 2 with one of her prior lawyers. Maybe we can maximize our court time if we can stipulate to proceeding without Rule 2. I think that also helps keep the costs down. I always favor streamlining and simplification, but we need to follow the rules of evidence, so I won't agree to waive Rule 2. That just isn't appropriate in the light of the allegations here. There's way too much inappropriate stuff being brought in by your side, so we need the evidentiary rules to help narrow things down. 3. Witnesses. Matt, Greg, Mike, Wood, time permitting and consistent with the disclosure, will testify that they experienced false pregnancy claims, altered medical records, suicidal thoughts or threats of breakups, behavior with their families, and abortion contingent on relationship contracts, etc. Our disclosure statement is reattached for your convenience and includes a summary of their testimony. I am not sure what happened with your call with Randy, but she likely did not recognize your name, as you are not the first attorney Laura has had in this melee. Okay, no. Okay. So, we'll continue on with that in a minute, but I want to make this correction. This is from Woodnick. Gingras sent something about some comments back in red on the 22nd of April, and then but Woodnick had sent this witness stuff first before that part. So this is Woodnick stating all this to Gingras. Had in this melee. I have spoken to her, but it was months ago and before your involvement. I have confirmation that Mike fully supports this process. Of course, I can subpoena him, but that won't be necessary. If you call Blank, she will confirm what happened with Mr. Blank. I sent Gillespie your contact information, so hopefully you connected. If you feel you need more information per Rule 49J, that is not included in the attached, let me know. Okay. So what I think is happening here is the numbers on things are probably Gingras in the bold, and then below that is the response from Woodnick responding to each and every single one of these. So his response of the witnesses says, just FYI, based on comments above, I'm going to file, nope, it is Woodnick. I am sorry this is so confusing. Woodnick has got the numbers, and Gingras is the one putting his response on there. Okay, so when we go over the number thing, that is Woodnick. When we go over the unbolt parts after the number things, it is Gingras. Just FYI, based on the comments above, I'm going to file a motion in limine to preclude the testimony of Matt, Mike, and Greg. This is classic prior bad act evidence that is not admissible under 404B. In addition, you have, see, yeah, that has a little bit more attitude to them. It could be just the way I'm reading it now, that I know who's saying it, but it still has more attitude. Just like there's way too much inappropriate stuff being brought in by your side. No. Your client is lying too much, so we have evidence to counteract that lie. Never disclose the substance of any of these people's expected testimony, and it is clear that you had that information more than 30 days ago. So the motion, I was going to say mother-in-law, motion in limine will argue both 404B and untimely disclosure, and frankly, relevance. An unproven allegation from an angry ex-boyfriend is literally meaningless in this situation. Really? An angry ex-boyfriend is meaningless. Well, would you be mad if somebody lied to you? Like, and actually showed you all this fake test and took you to court and you had to pay out a bunch of money? I'm not talking about your little, I once had to go take a free paternity test from the courts. It cost me zero money, just a little bit of time. Like, you have no idea what these men have been through. But yeah, their situations are meaningless. 4. Experts/doctors. Remember, this is Woodnick stating, I forwarded your experts draft to our experts. I'm a little confused by your expert report, and while ours forthcoming will certainly not align and was delayed because we are giving Planned Parenthood a second chance at providing an ultrasound, I don't think your doctor's testimony, if accepted by the court, addresses the fundamental problem of your client's behavior in this litigation. Once we receive the final version, we will be making specific content objections permitted by law. I am not going to engage in a debate over facts. We can do that in court or with a mediator, as was previously suggested. Parenthetically, I would point out that your theory about weight gain is quickly refuted by your client's own medical records. Per her Banner Health record, she weighed 121 pounds on June 1st, 2023. Yeah. But, and Banner Health seems like the only thing we can go on. And that is why she is willing to be like, do you want my login to my patient portal? No, nobody wants your dumb stuff. None. Okay, Gingras' thoughts on this particular thing says, I am hoping to give you MedChill's final report today, and this will include more information that you don't yet have, such as an affidavit that Laura gave to MedChill, as well as my cover letter to him, which explains the scope of testimony I asked for, as well as some specific questions I asked him to consider. You obviously need that additional information to provide context, so this will be sent to you today, if possible. We have seen that. We have gone over that in another video. Since I don't have your expert reports, I can't really speculate about what they are going to say, but based on the limited info in your third disclosure statement, I am probably going to bring a motion to exclude your experts based on 702, Daubert, and relevance. I'll let you know once I see the reports and have the chance to discuss them with Dr. Medchill. Side note, your third disclosure statement says Dr. Deans is going to testify that HCG tests were never dispositive of pregnancy. Assuming she says this, which is hardly a contested issue, I think it's important to remind you that you are applying exactly the wrong standard here. Yes, please point out how you are the all-knowing Oz. The only remaining issue is whether Laura should be sanctioned for bringing a claim she knew was false. While you are going to lose that argument for other reasons, to obtain sanctions, you seem to believe that Laura has some obligation to show you with 100% degree of medical certainty that she was pregnant. That is what the JF crew has been claiming for weeks. No, I don't think that's what we've been claiming. I think what we have said is she shouldn't have filed this case. If she knew back in July she was not pregnant, she should have never filed this on August 1st. But the fact that she lied about everything, that is why we don't believe. We would have been able to forgive that she thought she was 100% pregnant. And then when she found out, had she had gone to actual doctors and got ultrasounds and all this other stuff and had prenatal care, and then she found out she wasn't, that the HCG test was actually positive for something else, none of us would have a problem with Owens, because that would show integrity and honesty. But that's not what happened here, Gingras, and you know that. So stop focusing on the JFC crew, the pond scum posse, us little pleb non-lawyers, and focus on the truth. And hopefully you are not out there speaking lies to a judge that you know are not true. If you want to play stupid and not know, okay. Many defense attorneys for criminals do that. He never told me that he actually did it, so I don't know if he did it or not. So I can come up here and say he's innocent. If that's how you want to play, so that you can go up there and fight for your client and not know the whole truth, then go on. But don't sit up here and say that you're searching for the truth, because you're not. You're searching for a win. These men are fighting for their reputations and their names, not for a win. A win comes with that, sure. That's all they've wanted. That is exactly backwards. Laura simply has to show that she had some reason to think she might be pregnant. If she had the basis, she cannot be sanctioned. Even if her belief was wrong, at no point is she obligated to establish the pregnancy was confirmed in some dispositive manner, whatever that even means. This just another reason why I will probably move to exclude Dr. Dean's testimony about HCG tests not being dispositive. Who cares? That is simply not relevant to the issue in this case. Honestly, I'm guessing Dr. Deans would agree that a positive HCG test does give a woman a reason to believe she probably was pregnant, which would make her a strong witness for Laura's side. I guess I'll ask her when I see her report. The problem is she shouldn't have filed this, and she shouldn't have continued on with it, even if she could have filed it. She shouldn't have continued on with it and doctoring stuff. That is not okay. And for that, she should be punished. Number 5, Woodnick says, motion for judgment on pleading and intent to file for sanctions against me personally. If this is how you choose to litigate, and to relitigate things that have already been addressed and denied, then a phone call to discuss is not going to impact anything. It will be more posturing, and I don't think it is helping our clients. File what you must, and we will respond in kind. I don't understand what you mean by this. Things that have already been addressed and denied? I think you must be referring to the fact that Laura's prior counsel asked the court to dismiss the case, and then the judge apparently granted that and then changed her mind. Those are two completely different issues. My motion for judgment on the pleadings is going to argue that you cannot get sanctions as a matter of law because you didn't follow the rules. I don't believe that the issue was fully raised before, which is why I'm going to raise it now. As for the ARS 12-349 issue, that pretty much speaks for itself. He's such a pleasant person, right? He's so pleasant. Number 6, meet and confer. The purpose of a meet and confer is to discuss possible resolutions of issues. If you have proposed settlements, just a minute, let me close the door. Well, okay, maybe I can't slip the door. Okay. Okay. Over the phone, I am happy to coordinate the call, but I am not interested in the scorched earth Conor McGregor stuff. You apologized previously, but reverted to the same behavior online via Twitter and your blog. If you really think a call would be productive, I am happy to coordinate it, but your mind seems very made up, at least from your blogs and whatnot. If you think a call would change your perspective about what you are going to file, I will find time to talk with you this afternoon. Gingras says, did Dave Neal ever share the long email I sent you? Have you seen it? Let me know, and I'm happy to share it with you. The point is, you misunderstood what I meant about Conor McGregor. I don't think we did. Because when you make a statement like this, I'm sorry, your excuse that you're fixing to say here makes no sense. That is not what anybody would gain from that. Like, you could have put it differently, but you put it in that way because it seems aggressive. As I explained to Dave Neal, I have been involved in many cases that were much more contentious than this one. And in many of those cases, opposing counsel ended up losing their license, and in more than one case, the lawyers ended up in jail. The Conor McGregor references simply means I've been dragged into a lot of really nasty fights, never by my choice. And in many of those fights, my adversaries have ended up self-destructing while I'm still here standing. That's what Conor McGregor means to me. Well, that's not the common meaning of I am the Conor McGregor. That's not what Conor McGregor is known for. He is known for nasty fights and being aggressive by any means necessary, basically. He wants to destroy you. So how was anybody supposed to know? If you didn't want people to think that, you wouldn't have put it like that. So I'm not buying your BS you're putting here, Gingras. It was never a suggestion that I enjoyed violent confrontation or I am out to gratuitously hurt anyone. My point was to say that I am a veteran of many tough battles, and while I would prefer to avoid messy conflicts, I am not afraid of going in there if given no other choice. Well, then you could have said you don't ever back down from a fight, no matter how messy it gets. Like, there are other ways you could have put your point across like that, but you didn't choose to put it that way, and that's for a reason. Having said that, I do think we should talk because there are so many moving parts here, among other things. I just want to get a clear understanding of who is really coming to trial and what they are going to say, bearing in mind I'm still going to seek to exclude pretty much all of your witnesses based on the lack of timely disclosures. That's your job as an attorney, is try to knock out things for the other parties to use. Because the less that they can use, the less chance they have to beat you. Like, that's your job. You can zealously advocate. Nobody cares. It is hard to have a conversation via email, and yes, I am more than happy to give you a verbal summary of everything on my side as well. Speaking of which, now that I fully understand the case from Laura's side, which is a lie, I would really find it helpful if you could give me additional detail from Clayton's side, especially with regard to this claim that Laura faked pregnancies with other men. Let me give you an example. In talking to Laura about this, I asked her to explain the story of Gillespie. I was curious to know exactly what basis he had for claiming she faked being pregnant. Have you not paid attention to Dave Neal? Because you seem to be obsessed with him, but it doesn't seem like you've actually watched any of his videos. Because otherwise you would know what we mean by that, what Greg means. Laura's response was paraphrased. She had a brief relationship with Gillespie. I think she said they had sex twice and went on like roughly 6 dates over a period of a few weeks. Laura tested positive for pregnancy. Gillespie asked her to terminate the pregnancy medically, which she did about 4 weeks later by taking pills in Gillespie's presence. According to Laura, that is the entire story, aside from her later litigation, which went nowhere. There was never any ultrasound. Why would there be? And there were basically no other medical records involved other than the initial pregnancy test and the later medical abortion. Assuming Laura has accurately communicated the above facts, she didn't, because otherwise you would know about the sonogram. But she's not going to own up to that. It's another lie you're going to catch her in because she's not giving you everything. The fact that you are finding all this out from Clayton's side and not your own client, that is a huge problem, Gingras. Like, what is wrong with your client? I'm guessing that Gillespie's only basis for the claim that Laura faked the pregnancy is because what? He just doesn't think she actually got pregnant? No. There are voice memos. There are altered sonograms, stolen sonograms, Fiverr images. That is why he thinks she faked it. Because there is actual evidence. Not because he just had a hunch, a gut feeling. That's not what happened here. You need to get your client to start telling you the truth. Gingras goes on to say, pure speculation like that is clearly inadmissible. Well, no shit, Sherlock. And if you tried to call Gillespie as a witness and ask him whether he thinks Laura faked being pregnant with him, I'd object due to lack of foundation and calls for speculation. There is no speculation here. She lied. When you have doctored sonograms and stolen sonograms and Fiverr logos on sonograms, I don't think it's speculation. And there's plenty of foundation to back all that stuff up. After this, many years of legal practice, you should know this by now. You can't just call a witness and ask them to guess about whether something happened. Nobody's doing that here. You're missing the point. That witness must first prove they have personal knowledge of the matter in question. He does. It was text to him. It was message to him. He has it. Personal knowledge. She sent it to his personal cell phone. I see no basis to establish that Gillespie had personal knowledge of Laura not being pregnant. Same thing with Maraschini. His lawyer also told me he's not testifying at trial. Same thing with blank. 7. Moving forward. This is going to be Woodnick. I know Laura wants this to be over, and candidly Clayton does too, but that requires her acknowledging how dishonest her behavior has been. I only speak for Clayton via Rule 408, but he does not seem interested in more litigation, both because Laura is probably judgment proof and because he wanted the same thing since day one. He does not believe the pregnancy, as they did not have sex, and for all of the myriad reasons you already know, including nearly identical stories from 3 other men. Now, when we say identical stories, Gingras, okay, we're talking about the pregnancy parts. We're not talking about relationships. We're strictly talking about pregnancies, ultrasounds, and medical documents. Not the type of relationship it was. Okay? Okay. All Clayton has ever wanted is an acknowledgement by Laura she has a pattern of lying about pregnancies to force relationships with guys who have rejected her. Even accepting, which we don't, that she was pregnant without intercourse and your expert's conclusion that she was pregnant with Clayton's twin children without any DNA testing with a fabricated ultrasound, it does not change what has happened since her alleged miscarriage or her conduct predating this litigation. This ends either with a trial in June or Laura coming clean. This is her out. She can fess up, but she won't. And that's why there won't be a settlement in this case, because Laura is not going to admit it. She will lie to your face and tell you that the sky is red and not blue. I am happy to discuss settlement. This is Gingras. But I also need to be honest. When Laura prevails in this case, she is going to sue Clayton and many other people for defamation and other torts. We can certainly avoid that if you want, but it's going to involve someone writing a very large check to Laura. If you offered $1 million right now, I'd advise her to reject that offer. So, yeah. Happy to talk about settlement if you want, but I don't think that's likely to happen. It's not. And there's your motive right there, Gingras. Money. She wants a large check from people. That's all she wants, is money. Number 8, Woodnick says, process. Assuming she wants to continue down this litigation path, are we agreeing that witnesses by video and no more Rule 2? We can still preserve Daubert 702 issues with regard to the docs. And it says, I think we can at least agree on the video issue. Signed, Greg. Then we have previously, on April 19th, 2024, from Gingras, Greg, we need to talk about witnesses. I am asking because obviously it's not possible for you to call 9 people in 60 minutes your side has. I am also asking because when I see newly disclosed witnesses as here, and there isn't any disclosure about what the person is going to say as here, I like to just pick up the phone and ask the witness. So I just tried calling the contact person you had listed for Mike Maraschini, Randy Pollock. Randy really surprised me. She said she had never heard of this case, never heard of me, never heard of you, and as far as she was aware, Mr. Maraschini wasn't coming to testify as a witness, a trial witness. So then, if she hadn't heard about any of this, then maybe that's not who Maraschini is using. Maybe Woodnick thought that Mike was going to use that person because he's used her in the past, so he gave you that. But I'm sure he will find out about who the lawyer for Maraschini is. I also tried contacting the person that you listed for blank. Got voicemail. Hopefully she will call me back. I was going to call Greg Gillespie, but it's not clear to me whether he's represented by counsel. Your disclosure does not say you're representing him, but I know you previously had that prior relationship. So please clarify whether it's okay for me to talk to him directly or whether you want to go through you. If I don't get any response, I'm considering whether we should just depose these folks, but I'd like to avoid the extra cost if possible. Depose them. You want to know something from them? You want to talk to them? Depose them. Because that's probably the only way you're going to get them to sit down and have a conversation with you is on the record. Anyway, The easiest thing to do here is for us to have a conversation about who you are actually planning to call at trial. Right now, my witnesses are Laura, Clayton, Laura's mom, and Dr. Medchill. Why not her sister? Her sister should be able to back up her story, right? With those pictures and so forth. She sends her sister everything. So why not her sister? Shouldn't her sister be able to help her Owens out? I am planning on sending you an updated disclosure statement next week, which includes summaries of all witnesses' expected testimony, plus all my trial exhibits. And if Dr. Medchill's report is ready by then, I will include it as well. Remember, this is prior to the May 10th deadline that has already passed now, but it hadn't at this point. On that note, I'd also like your input on whether you are okay with having out-of-state folks appear by phone or Zoom or whatever. Medchill lives in Florida, but he has family in Arizona, so I think it's his first preference is appear remotely, but he can also be here in person if that's the only choice. I'd appreciate getting the same info from you, which people you actually plan to call, and what they're going to say. Obviously, it should come as no surprise that we are not expecting you to wait until the last minute, i.e. May 10th, to file disclosure, the substance of which each witness is going to say. If that happens, I'll move to exclude all that info as untimely per Rule 49B2B, since you didn't disclose it within 30 days of learning the information. I'm also considering a Rule 404B motion in limine to Gillespie, Maraschini, and blank. But I can't really do that without knowing what you plan to have them talk about. At this point, he had not received an email from Maraschini and Gillespie. So they hadn't told him yet. Look, despite all the animosity, there's still a lot of stuff we can do to get this thing ready for resolution. All I'm asking is for you guys to follow the rules. I am trying to do that, and it's not unreasonable for me to ask the same from you. Signed, David Gingras, Esquire. So, that's such a douche way to sign your name. Alright, and then here we have some text that says, where you just wrote that you didn't intend to date me. You are so damn wrong, and I will find out how much I am, and will find out how much I am not. You deserve as many legal issues as possible after what you did to me. So here she is threatening him with lawsuits and all the legal things she can do as an act of revenge. Notice all of this is her and not Gillespie. All I have wanted is to date without pressure. If you want to keep your word and go on dates with a good attitude, I'll drop any lawsuit for good regardless of the outcome. This has been so much pressure on us, and I am not trying to get you to fall in love. I just want to do everything you said you wanted without the weight of this on us. And you're right, I can't control the outcome of that. But blocking me right after is complete coercion. Lord. She's got to drop that in there so that it's in her, so that she can use it in her lawsuit and her restraining orders. You will get served tomorrow. I am going to urgent care now to get an ultrasound because this has pissed me off. Guessing you don't care to know/see the results since you asked me an hour ago for them. If there is, I will not be getting a surgical abortion and instead will get an order for a DNA paternity test and file for child support. Which she didn't do in the Gillespie case, but she did it in the Clayton Echard case. And why are you going to urgent care for this stuff? Go to an OBGYN, which you should have established by now. But yeah, keep going to urgent cares for this stuff. I have never been involved in a lawsuit in my life. Well, we know that's a lie. That's a flat lie right there. But you have ruined my life by manipulating me into having an abortion when I did not want one, and then had the balls to now say that this is harassment. You are a 35-year-old coward. You deserve to be embarrassed after what you did to me. And you know what? Now karma's coming back to bite you in the ass, Owens. You deserve to be embarrassed after what you have done. Here is the One Medical. One Medical is attached to Amazon. It is a telepatient, teledoc thing. She's under the scheduled visit. She has an account that says LO. Okay. So it says, or no, maybe she's under messages because messages is underlined and this looks like messages. It says Owens, you, August 25th, 2021 at 8:08 a.m. Hey, Julie, I'm not sure if you remember me, but you were so kind and concerning back when I did my video visit. I just found out that I was pregnant and the father of the child didn't believe John's note, nor the urinary test results stating I was. The father wanted me to have a video visit since I didn't allow him to access my portal, and I had to use both a computer and a phone to have him be able to see you. Anyway, you asked him to leave and said you thought he was behaving oddly, and if I ever felt safe. I did at the time, but things have changed as time has gone on, and it's become extremely obvious. Right hat. He does not want a child to be born. I contacted the police to report his behavior. He hasn't touched me, but he has been intimidating, threatening, and manipulative. And what do? You intimidate them with lawsuits, police phone calls. You manipulate them into trying to be with you so that you won't have a baby. You threaten them constantly. Like you are being everything that you're saying they are being. She says, I am safe now. I just remember if you had any recollection of this behavior that maybe come off as odd to an outside that me. She does not know how to type. As the mother of his expectant mother, you may have wanted to ignore. You were the first one to say something about it, but haven't been the last, and it is helpful to see someone else's perspective, since I haven't wanted to see the bad in him. Thank you. Julie, the nurse practitioner, wrote back, Hi Laura, Julie here. I'm so glad you reached out. Sorry to hear about how things have gone since we last spoke. I would like to call you when you are in a private space with 15 to 20 minutes to talk. Are you available this afternoon? Warmly, Julie. Okay. I didn't allow him access to my portal. Why didn't you allow him access to your portal, Owens? Because you have no problem saying, you can have my Better Health login patient portal, but this one you want to keep private? Why? We have questions. Here is clinical team Julie. It is with the Lighthouse Bali. So it says Julie Ulrich, medical director, which is the person that she was talking to in that message just a while ago, or supposedly was talking to. Julie Ulrich, MSNFNP, CNS, is a graduate of the University of Iowa and the Catholic University of America in Washington, D.C., where she completed 2 master's degrees, one as a family nurse practitioner and the other as a clinical nurse specialist in public health. Family nurse practitioner Ulrich has been working in the primary care for the last 20 years, providing care in the diverse and multicultural communities of Washington, D.C., and on the Native American reservation in South Dakota. She also has an extensive experience working internationally in Haiti, Russia, Dominican Republic, Lesotho, probably pronounced that wrong, Vietnam, and Indonesia. This experience gives her vast knowledge of how different cultures perceive medical care and experience illness. During the entirety of her career, family nurse practitioner Ulrich has worked exclusively with clients who live with substance abuse issues stemming from her background as an HIV specialist. It is her belief that given the opportunity to change and proper support, people with addictions can and will transition to a life of sobriety which can transform their own lives and the lives of their families. As an assistant clinical professor at George Washington University College of Medicine from 2011 until 2014, family nurse practitioner Ulrich taught and trained nurse practitioners and medical students involved in community-based primary care services. Her love for teaching extends beyond the classroom and is found in every client encounter she has. It is her strong desire to use these experiences to assist the Lighthouse in providing culturally sensitive care to individuals and family needing drug treatment services in Bali. So that is the bio, or at least what we have of it, of this lady. Said she can do all this in Bali and all these other places and talk to Owens because it's the telehealth system that she's using that goes with Amazon. So this person didn't see her in physical person, like she saw her over a video call. Owens goes on to say to Gillespie, if you bullshitted me to kill human lives for your own selfish, cowardly benefit, I will make sure that the law makes you pay for the consequences of your actions because they are completely inexcusable. I'm not the crazy one for believing you liked me. You would be a domestic abuser of the worst type for that level of manipulation. No, I'm pretty sure somebody that's trying to kill somebody or almost killed somebody, lit them on fire. There's plenty of ways to be a worse type of domestic abuser. Telling somebody to get an abortion does not make you a domestic abuser or the worst type. They're stating their opinion. Is it something that a lot of women don't want to hear? Yes. Especially if you love them or you saw a future with them and all this stuff, and then all of a sudden this is said. But none of that stuff was going on in Owen's relationships. They had gone on a couple of dates. And then she did this. And then they saw how crazy she was and said, I don't want children with you, woman. Get rid of it. Or if you are even pregnant, you know what? You can get rid of your fake baby. Owens says, if that's who you are, the civil lawsuit stands as it's already been filed. I will file for a criminal lawsuit for your actions against unborn children. I will have the court order you take a DNA test, keep the child if it survives, and raise it in a great environment and put child support on you, and you will pay for medical expenses if there's a deformity. You're the one who took the pill, woman. But you want money. Motive is money. Money and relationships. That's all you care about. And nobody wants to give you either. Don't you dare act like I'm desperate and crazy for believing your word. Let me know what you decide to do. She continues to yap on, saying, I'm planning on filing for punitive damages first thing tomorrow. If we're not on the same page, so I am presuming you're not responding means we are not, since I am sure you've seen my messages. I am not playing games here, and if you want to ghost me, that's fine, but I'm moving forward. Confirming that these messages sent the day before were fraudulent promises that you knew would cause extreme emotional distress when broken, aka DV, you are leaving me no choice but to press criminal charges. I have offered to get a surgical abortion or have a DNA paternity test. So how is he coercing you into doing this if you have offered to do these things for him? How is he coerced you into having an abortion or taking pills? You brought it up. hey, I'll have an abortion if you agree to date me. And he said no. Or he said, yeah, sure, let's do that. You told him you took the pill. You only took one, or you didn't take any. But you've also had severe allergic reactions to abortion pills, so why are you seeking them out if you're allergic to them? You've also been told that they wouldn't give them to you outside of the clinic. So is this plan B, or is this something else? Like, things are not adding up, and your math is not mathing. I would drop all charges if you kept your word. That's all you have to do. You must have wanted some resolution when you were suggested meeting up today. Yet to tell you to go away. Leave him alone. So those were the messages that were attached as exhibits in the motion. Here is the entry and order. It's in the matter of Owens v. Echard, Gingrich and Woodnick, and this is given by the Honorable Judge Matta on May 16th, 2024. Order entered by court. The court received and considered a respondent's motion to withdraw motion for sanctions pursuant to Rule 26 filed on April 3rd, 2024, and petitioner's notice of non-objection filed on April 4th, 2024. It is ordered the motion is granted. Respondent's motion for sanctions pursuant to Rule 26 filed on January 3rd, 2024 is hereby withdrawn. Which means this long motion and such was not needed. It is further ordered affirming the previously set trial evidentiary hearing on June 10th, 2024 at 8:45. Let the record reflect, due to clerical omission, the rule was not issued. Additionally, the court originally issued the ruling on April 4th, 2024. So she did rule on this, but for some reason it wasn't put in. And then it goes on to say all the parties representing themselves, can download this form and stuff. So the Rule 26 sanctions are off the table. We should not hear about the Rule 26 sanctions anymore. They are moot. And ending with our quote of the day, every time a fool opens its mouth, he advertises its absence of intelligence. And I feel like this is what Gingrich does. Owens most certainly does it. But Gingrich is starting to do this. He's starting to look like a fool. But if you like this video, hit the like button. If you want to know when other videos come out, turn that notification bell on and subscribe, and I will see you in the next one. Bye.